All right, the last case that we have on the docket this morning is Wells versus Circle Redmont. Are all the parties here?
Yes. Hi, good morning to the panel. Judge Cohen, I'd like to reserve 5 minutes for rebuttal.
Very good.
First, for the panel, I'm sure you know the facts. It's obvious you know the cases before you and you've read the briefs. So if there are any questions the panel has before any statements I'd make, I'd take them now, or I just move into, don't have a desire to bore the court with things they've already.
Well, let me ask you this. Did the contract provide that if your client didn't approve the shop drawings within a year, that the price could be adjusted?
Yes, it absolutely did.
All right. Now, it's their position that they did, well, let me ask you this. Was it more than a year before your client approved the shop drawings?
Yes, it was.
All right. So they had a right to adjust the contract?
Yes, adjust the price of the contract.
Adjust the price.
Yes.
Well, I think what it says is the pricing and payment terms, and you never below or on appeal challenge the validity of that provision.
No, that's a clear provision within the contract. If it took too long to approve the drawings, they could increase the price for obvious reasons. Maybe the price of materials went up, the price of fabrication went up, but they could increase the price of the product.
Theoretically, under that provision, they could have doubled, tripled, quadrupled the price unilaterally, but in any event, the point being that provision was not challenged.
Okay, well, I disagree. They're supposed to give you a reason for it going up because of fabrication costs. That's what the contract said. So no, they couldn't double the price of the skylight.
Why not?
The contract says if it goes up because of fabrication costs. It wasn't a get out of jail free card and charge you $1 million for a dollar item.
Well, did they say
more? We get it.
Did they say we're adjusting the price by removing the installation portion of our contracted for work?
After they did it, not before.
Here's what it says. If seller is prevented from processing due to delays in performance by the customer or conditions of the building, seller may adjust the pricing and payment terms of this order after 1 year from the date of acceptance, period.
Well,
So it doesn't, it's not, it doesn't put any limitations or conditions, but in any event, the point I'm making is that you never challenged the validity of that provision in the contract, correct?
Not as to their ability to change the price. There has never been a change. My client's argument has been they didn't change the price. They left the price the same and took away one of their obligations under the contract. If I buy a car, I get a warranty. If I take that car outside of the warranty period and have somebody fix it, I violate my warranty. Here, they took away all their obligations, and the judge modified it so they didn't have to install. They had no obligation to put it in. And now, when my client had somebody else put it in, if they break it or if it's not right, then he loses warranty rights and everything else. It was a material, negotiated term having nothing to do with the price.
Right, but the trial court found that you all, by conduct, agreed to that, and I think that there was some evidence in the record that I'm not sure, it might have been the roofer or the person that was involved in the construction, that person went to Circle Redmont and was arranging, for installation.
Yes, Your Honor. The only evidence in the record relating that you're addressing the conduct that was making a payment under the contract in conformance with the contract. There was nothing new, no additional charges, nothing to tell a third party or CRI that he consented to any change in the obligation for fabrication. The second issue, dealing with the roofing company and a personal friend, that's agency law, and that's briefed for the court. And here, there is no evidence whatsoever that Mr. Wells ever represented orally or in writing that he had any agent on his behalf. Every representation was trial was a representative of the purported agent, not the principal. And the law that's been approved by this court and other courts is an act by the agent, by the principal, will bind the principal, not the agent. We could all go around and say, I represent somebody, and you can rely on it, and if he does nothing to confirm it, I could bind him. That's not how it works. And if you look at the record...
How much was attributable under the original contract to the installation?
I don't know, Your Honor. It was a...
2,000.
Was it 2,000?
It was a bulk amount.
2,000.
Yeah.
I'm sorry,
I wasn't the trial attorney in this, and there's some facts that I'm
All right,
not.
but would it have been okay, let's assume it was 2,000. Would it have been okay if they had said, look, y'all took a year and a half to approve the shop drawings, we have a right to modify, so we're going to increase the contract price 2,000.
Yes.
All right, but you're saying it's not okay for them to say, we're going to keep the contract price the same, but we're not going to do the installation, which was a $2,000 charge.
Yes, because the contract, Your Honor, we all know what contracts work. I'm going to pay you for certain things. And what did I pay for? Mr. Wells paid for the fabrication of an item and its installation. He could have bought skylights anywhere.
Okay. Now, if they had said, we're going to charge you $2,000 more, would it have been incumbent on your client to say, that's too much, or we agree to
Yes.
it? All right. And if they say, we're no longer going to install, why isn't it just as incumbent on your client to say, no, that's not acceptable, or yes, it is acceptable?
Because he had a contract for installation. Their duties were clear.
But in the prior
I have to pay. I'm sorry.
prior
go ahead.
example, he had a contract for the price of the skylight.
And installation. It's a combined contract. They're not two separate contracts. I'm going to buy it, now will you install it? It was one.
So if they had increased
$13,500.
the contract price by $2,000, said, look, it took a year and a half to approve the shop drawings, we're increasing the price from $16,000 to $18,000, you agree that your client had an obligation to say yes or no at that time?
Right. No, he had an obligation to pay it, assuming it was a reasonable increase, yes, if that's what the court's asking. So my client does not and has never disputed a right to increase the fabrication charge, or whatever the charge may be, the payments under the contract, assuming that year passed. That's not was never an issue for the court. What the issue was, instead of increasing the price of what he bought, they changed what he bought. What he bought was installation, warranty, and the product. What he got was the product. And if you look at the contract and the storage charge...
At this point was nothing, right?
I'm sorry, Your Honor?
At this point, what he's gotten is nothing.
Nothing. He has no skylight, and we have another appeal on that issue because it's still out there floating around. But,
There's another case?
yes.
Okay.
The skylight's still in the possession of the appellee, and it won't be released with a bond posted. We've had some hearings, court released jurisdiction, and now that's coming up because it hasn't been released. So my client has paid for it, but it's still out there.
Let me ask you about attorney's fees.
Sure.
Your argument on attorney's fees is that this isn't a payment. Storage costs are not a payment. That you all paid right after the partial summary judgment, you paid the remaining balance of the contract price.
Yes, and that the storage charges as items that are subject to the attorney fee provisions are not identified. It says payments, and storage charges are termed charges. They have other things called costs. So, and they drafted it. It's their document. They're bound to it, and it should be strictly construed. Is it a payment? The storage charges are, in fact, charges.
Yeah, they also have a motion for appellate attorney's fees. Do you think that either you went on both or they went on both, or is there a possibility that one of you could win on one and not the other?
Yes.
Okay. What's the difference between the appellate attorney's fee argument and the trial attorney's fees argument?
We're up here arguing about storage charges. That's the reality of this case. Can you charge $50 a day without any proof of it? If the court deems that this proceeding is predominantly about storage charges, which I would submit to the court it is, and determines that the straight language of the contract says payments and not charges, then you could rule on our behalf for the judge not having substantial competent evidence to rule on, to find a damage, and rule that this proceeding is not subject to that contract provision because it was about charges, not payments. Yes, Judge Cohen, I'm sorry.
It's also about attorney's fees.
Yes, because two were combined. I'm sorry. They were
But
separate
after you
appeals.
all paid on the partial summary judgment, you paid, after you all paid, a week or so after the entry of the partial summary judgment, you all paid the remaining balance on the contract. Okay, at that time, any attorney's fees incurred were related to the storage fees. Would you agree with that?
Yes, that's our position.
Okay.
Interest also, but it was interest on the storage fees, so it's really storage fees.
All right.
There were two things going that way, but the interest could have been defined at the partial summary judgment stage right then and there, but the judge couldn't because he hadn't determined what future storage fees might be. And just briefly on we talked about motions for directed verdicts. That's just a procedural decision for the court. I could not find anything saying you waive.
No, that's what the rule says.
Pardon me?
That's a motion for involuntary dismissal, right?
Right, yes, sir. It was inappropriately termed a motion for directed verdict, but when you look at the waiver law, the Supreme Court cases that are cited say you waive the right to raise that issue if you don't bring it at trial, and that was done. So
The rule
that's
says you do it at the end of the plaintiff's case, basically.
well, it says you may.
I mean, if you tried the whole case, it's a non-jury trial, the judge is the finder of fact, and,
Right, so,
why not just get a...
Oh, I'm sorry, Your Honor, go ahead. So, to the extent, we cannot find, there's not any language of waiver in that rule at all, and it's permissive language, not mandatory, and the cases don't establish a waiver.
The reason there's waiver is because if you did a motion at the end of their case, the judge, they didn't put on evidence on this point, and the judge turns to the other side and says, what's your response? And they say, Judge, we'd like to reopen and put that in. The judge would have the discretion to say yes or no. So if you don't make the motion, then we don't know if the judge would have allowed them to reopen, so therefore it's waived. Now, once they put on their case, once you all put on your case, then the judge has heard everything, and if there's a lack of evidence, then the judge should rule your way. If there's, not...
On the merits.
Merits.
Yeah.
But that's why there's a waiver, is because you've taken away the judge's, their opportunity to ask to reopen and the judge's opportunity to possibly grant it.
Okay, well, that may be this court's ruling in construction, but candidly, I haven't found any rulings expressing it that way. And so it's an open thing for this court to...
I think there's some case law out there.
I couldn't find it, and mea culpa. But even without that, when you get to sufficiency, if this is sufficiency of the evidence case, substantial...
It's very difficult to suggest that there's no evidence of the $8 that the judge found when your client testified to it.
Well, actually, Your Honor, if in the reply brief this is addressed first,
Right. You
the
can't
appellant
address
and
an
their...
argument for the first time in a reply brief.
No, Your Honor, it's in reply, it was in our initial brief also. The facts are, the judge clearly found their evidence insufficient. She said it was unreasonable, and it's all through the record. $50 a day, there's no evidence supporting it. She
sustained the objection to your...
Well,
and then when Mr. Wells spoke, and off the cuff said, well, I've had some storage facilities and I've done this, it was objected to and sustained.
We have the unique position here where you're telling us, don't rely on the evidence from my client, and they're saying, yes, please rely on the evidence from opposing client.
And partially, if you take their argument, then there is no evidence because the judge said there was none, and now they've said there's none with the client. If you take my client's evidence, there was no evidence of industry standard. There was no evidence of how many storage facilities he had. There was no evidence of how much room that skylight would take in any given storage facility. It's just devoid. It was conclusory.
No, there was evidence of the size of the...
Right, but there was no evidence, Your Honor. Could you buy a smaller unit than the one my client opined on? Could you put it in something else? Are there smaller units available? Everybody knows what a skylight is. It doesn't take an entire storage facility to take care of it.
The trial judge is trying to do your client a favor. I mean, your client heard from them saying $50 a day, and the judge thought that's just excessive. I'll just go with the 8 that they use. I mean, I have a feeling the judge is trying to help your client out on that.
Right. Well, appreciating the good feeling from the judge, that's not what she was supposed to do. She was supposed to look at the evidence
Well, but there
and have
was
a correct
evidence.
measure of damage.
Your client testified that he had knowledge of storage units in the area and that $8 a day, you know, it came to 8. I think he testified as to it in terms of a monthly payment that, you know, 240 or whatever the amount specifically that he came to was a reasonable storage fee.
Yes, Your Honor, and then he tried to express other things that he knew about the storage facility, and she rejected it. Each one of his statements, wouldn't allow him to explain other rates, nothing. All she allowed was the one statement, and then she impermissibly relied on a past case with this same manufacturer.
All right, you're inside your 5 minutes now.
Yes, sir, thank you. So here, they've conceded that there's no evidence in their brief. We've conceded there's no evidence in the brief to support the damages. If there's no damages, they failed on their element, and regardless of what she granted.
I don't think they've conceded that, but... okay.
Well, this is my argument on, and we beg to differ with the court.
Okay.
If they didn't hit on their element of damages, then they didn't win on their case, and there are no attorney's fees. The attorney's fees come no issue. Secondly, if the court determines that they didn't have a right to take away an obligation, they had a right to raise the price but not take away their obligations, then the contract clearly states that if they had the obligation to install, then the storage charges didn't accrue until it went to the site. They kept it till they installed it, and then my client had to pay for storage at the site in the contract. If they weren't going to do installation, they could start charging fees while it stayed at their facility, because why do we have to keep it? Because we're not installing it.
You understand you're inside 4 minutes of your
Yes, sir, I do.
All right.
So it's important for the court to understand that by changing the pricing issue to allow it to affect other obligations in the contract, it affected the storage clause, which is the reason we're here today on this appeal. The amount of the storage fees and the attorney's fees relating thereto. And I would reserve the balance of my time for rebuttal. Thank you, Your Honor.
Thank you, counsel.
Good morning, Your Honors. Alan Whitehead here on behalf of the appellee, Circle Redmont. I wanted to bring a couple of facts to the panel's attention that to make sure we're clear on. First of all, originally there was an answer and counterclaim filed by Mr. Wells to the action. There were no affirmative defenses raised, and there were no affirmative defenses at issue at the time of trial. Also, in the counterclaim, and I allude to this in the closing argument before the court on the issue of credibility of Mr. Wells, and this argument related to the $2,000 upcharge or the change or modification of the contract by conduct. Mr. Wells, in his counterclaim, acknowledged that installation was removed from the contract. Mr. Wells, when he paid the amount after the summary judgment, didn't pay $7,155. He paid $9,155, the additional $2,000.
He paid the contract price at that point.
He paid the full balance.
So if he paid the full balance, I'm trying to understand why the storage fees continue to accrue.
Even to today.
Because
and even maybe 30 years from now, under the final judgment.
based upon the final judgment, yes, Your Honor.
How much sense does that make?
Here's why it makes sense. Because under the contract, if the contract's breached by Mr. Wells, and if he does not pick up when it's time, if he does not pay and pick up when it's time to pay,
You all wouldn't
pick up,
let him. You wouldn't give it to him. After he pays the entirety of the contract price, you won't give it to him because there's a dispute over storage fees and attorney's fees, and so we're going to continue this, the meter continues indefinitely.
There's a dispute over storage fees and interest, which is called for by the contract if you don't perform.
I mean, you got the benefit of the bargain, and you still got his skylight.
We actually didn't get the benefit of the bargain because the contract calls for interest and storage fees if you don't pick up.
He
And until
paid all
those
that.
sums are paid, he has not performed his obligation to pay
He paid the
pursuant to the
contract
contract.
price some 10 months before the trial. Right?
After summary judgment was
I
entered,
agree.
after we had to file
I
suit,
agree.
some 2 years after he was supposed to pay, or whatever I'm not sure of the date of that.
You got a
All this
judgment
time,
for,
we're storing the materials.
you got a judgment for the storage fees up to that, you got a judgment for storage fees, you got a judgment for attorney's fees. What right, or what obligation do they have to continue to pay just because, you have a right to collect the judgment. You got a judgment, you can go collect it.
Yes, sir, but understand that the contract, in order, and Circle Redmont, this contract was drafted by my predecessor at the firm, Judge Torpy, but the contract is
No
because
wonder
Circle
there are
Redmont,
problems with it.
That's right. That explains a lot.
Yeah.
but Circle Redmont does business all over the United
Can you
States.
find a case anywhere where after there's been a judgment entered, that storage fees continue to accrue indefinitely on a non-delivered product?
That issue wasn't raised for appeal, so I didn't look for a
Well, they're
case on
challenging
that.
all the storage fees.
They're challenging storage fees that were awarded at trial. They have not challenged the continued incurrence of storage fees until the item is picked up. I did not see that in in either of their briefs. And so as it relates to the payment of storage charges,
Well, they paid storage from the time he paid the $9,155 to the time of the trial, didn't it?
no, sir.
You did
They
not.
haven't paid anything yet.
Well, I mean,
They
you got a
posted-
judgment for that. You
they
got
posted
judgment-
a supersedious
you got a judgment for
bond.
that. You got a judgment to that date, correct? To the trial date? Or till the judgment was entered?
We got a judgment
10
for
months-
storage charges
he got
up to the
10 months
date
of
of the...
storage after he paid the contract price, correct?
No, sir, I disagree with that.
You don't-
Because he hasn't paid he didn't pay the contract price.
Let me rephrase it then. After he paid the $91.55, you've collected 10 more months of storage.
That's correct. Because the balance of the contract was not paid. And the balance of the contract still is
The meter
not
is still
paid.
running, right?
Yes, sir, the meter is still running. The balance of the contract has not been paid. And the reason that provision's in there, and the reason that Redmont does that, is because they do business all over the place. And if their product is delivered, then they lose the ability to collect. So they
But you all can
bargain for
stop the
that.
meter whenever you want. I mean, all you got to do is give it to them, use it for firewood, whatever, but you can stop the meter whenever and collect on your judgment.
Yes, sir. We can collect on, that's assuming you can collect on a judgment. If you can't collect on a judgment, then at least there's the product that's available to recoup some of that loss, and that's
that
the
some
reason
kind of
for that
lien that you-
contract provision.
That's in the contract. You get to keep it.
Was this guy like...
You don't turn it over until it's paid for.
Was this,
Everything due under the contract.
Was this a home that it was going into?
Yes, sir, a high-end custom home.
All right. So you'd have a lien on the property, correct? For
Well,
materials?
Maybe not. Probably not. If you did all the things right. There's no lien.
Assuming that you properly perfected your lien, I would think as a materialman or supplier, you would have the right to lien. That's correct.
Okay, but you all chose not to do that.
We wouldn't have a right at this point. The item hadn't been installed in the property yet. Understand that the delay was attributed not to anything Circle Redmont did. They fully performed under the contract. The delay was on the part of the...
Is there any part of that Torpy provision that allows to unilaterally change the pricing and payment terms that restricts the amount that you can charge?
No, sir. It just says
So you
the
could have
price
charged,
can...
theoretically, you could have doubled the cost of the item.
In theory, you could. I think there's some testimony at trial that the actual cost to fabricate the product went up more than $2,000, but that they settled on the $2,000 amount, just to get things done, and that was the testimony that was presented at trial.
Do you agree that the payment was consistent with the original contract? That when he made the payment, even though it was after this new proposal was sent to him, Was that consistent with the first contract or not?
It's the amount called for by the first contract. The amount did not change. What changed was the removal of the installation.
All right, so the evidence then of acquiescence to the new contract, or the new, whatever, I think you all call it a proposal/order. So the payment itself really would have been an ambiguous act in and of itself.
Just the fact of, I read what counsel indicated in his brief, that just because he paid, that doesn't show he acquiesced, or that he was paying based upon the fact that he got this modified contract and the payment came 6 days later.
What other evidence?
There was other evidence of that in the form of contract.
That's the front.
As you've already alluded to, the installer coming, as I've indicated, the counterclaim where he acknowledges that installation was removed from the requirement. I wanted to correct one thing, that and understand that our position is, and I think I made this clear, but our position is, even when the payment was made, that the contract was never satisfied, and it still to this day has not been satisfied as far as payment under the contract, because the contract says if you don't pay in time, we get interest at 18%. The contract said, which becomes due and owing under the contract. The contract says we have a right to hold the product until we're paid in full, and the contract calls for storage charges.
Now, the skylight's useless to you all, isn't it? It's a custom-made skylight. It's useless to you.
Well, I'm not sure, Your Honor, whether they, in essence, can take the product apart and reuse the raw materials. I don't know. There was certainly no evidence in the trial court on that issue. Practically speaking.
Once you got the final judgment, did interest continue to accrue at 18%?
No, sir. Interest accrues at the legal rate.
So why doesn't the terms of the contract merge into the final judgment with regard to the storage fees?
I think it does, but the final judgment at this point, and again, this is not the subject of this appeal, but at this point, the final judgment says storage charges continue to accrue at $8 a day.
Right, and why would it if the contract merges into the judgment like the interest provision does?
Because the judge ordered it, and because we requested it, and because it meets the intent of the parties as reflected in the written contract agreement.
Well, the contract, the intent was 18% interest on unpaid balance. It's now a lesser amount because you got your final judgment. The intent of the contract was to pay storage fees. You now have your judgment. What authority is there for a judge to impose storage fees ad infinitum?
And, Your Honor, my response to that is there may be some authority out there that allows this.
They didn't raise it.
I did not look at it because it hasn't been raised in this appeal. So I really can't answer that question at this point. The other thing that I wanted to make sure we're clear on, the issues that were tried were not simply storage charges. The issues that were tried were storage charges, what balance was due and owing, because Mr. Wells still disputed that he owed an additional $2,000 since installation wasn't included. That was also included as part of the issues that were tried. And, of course, interest was an issue that was tried.
How do you respond to their argument that the storage charges and attorney's fees are additional charges as opposed to payments as defined under the contract?
I think that's a very strained and impractical and illogical view of the contract. The contract, it's a payment that's due, and all payments are due under the contract.
You all wrote the contract?
Yes, sir.
And so it's construed against the...
Even construing it against the drafter, I don't see how there's any other possible way of interpreting it other than all sums due, all payments due under the contract, and certainly storage charges are due under the contract. Interest at the rate of 18% is due under the contract. I think it's attempting to play with words and the result being an impractical...
Isn't that what lawyers do?
Yes, sir, that is what lawyers do.
Okay.
But we as logical, common sense folks that look at these things that need to look at it and read the contract in its entirety and understand the purpose for those provisions in the contract.
What's your take on the evidence of the amount of the store, the per diem?
Yes, sir. I think
The court sustained your objection to his testimony, correct?
on the $6 per square foot, they were going to try to limit $6 per square foot based upon the size of the item that was to be stored. But there was not an objection. The testimony did come in that Mr. Wells, who of course, I think his testimony was, of course I own several storage facilities, and I could store this item for $240, $8 a day.
Well, $240 a month, I guess.
$240 a month is what he indicated.
There wasn't an objection to that?
If there was an objection to that, it was overruled, because that evidence did come in.
I don't think so. I think that
you
you objected to that evidence and it was sustained.
No, sir. I objected to the $6 an hour. That evidence did come in. That evidence of $240 based upon what he could do in a facility of his and how much it would cost to store it. That evidence was not objected to. The evidence that was objected to was $6 a square foot times what they were going to get to was the square footage associated with the item itself to be stored. I think on the issue of storage charges, I think that the issue came down to what the court deemed to be a reasonable storage charge because the contract was silent on the amount. We argued $50 a day, and we thought we made a compelling argument related to $50 a day because of the 3 notices that were provided to Mr. Wells indicating that that was going to be the charge if he didn't perform under the contract and pick up the item. He had the option to do that, didn't do it.
If he paid for, the $50 a day, and you're talking about before that.
Before that, yes, sir. We sent him a notice saying, if you do it, we won't charge you. If you don't, we're going to charge you $50 a day.
But he would have had to pay the remainder of the contract price.
He would have had to pay the balance due under the contract, yes, sir.
And including the $2,000 that was in dispute as it related to installation.
Yes, sir. That's correct. Unless there are any questions, as it relates to the attorney's fees, we believe that attorney's fees are appropriate for everything, including the appeal. Really? Surprise. If there are any questions on that, I'll be happy to address any.
Are you asking for $50 a day?
Now, that would be a bargain.
All right, thank you, sir.
Thank you.
Let me ask you about the testimony
Yes,
of
sir.
your client.
Yes, sir.
Question, and this is from your brief. How much would it cost you to store the skylight in one of your warehouses? Answer, you could put the skylight into a 480 square foot building, not a cubicle, but a bay, with an overhead door, man door, and a bathroom for $240 a month, and it would sit there all by itself. No objection. So now we have $240 a month for a 480 square foot building, which with nothing else but the skylight. So kind of, your client's kind of putting the max on it.
I didn't hear the last thing.
Putting the max on, saying, hey, you'd get
Yes,
it
sir.
for $240 a month. Actually, you can get it for a whole lot less.
Yes, sir.
Then the next question is the one that's objected to and the objection sustained. So the first part of you could, put a skylight in an empty building for $240 a month, that answer was not objected to.
Yes, sir. In my prior argument, I didn't mean to intimate that it was.
But isn't
what I said was
but
the
isn't
other
that-
explanations were
But
objected.
isn't that evidence, then, that you could put the skylight in an empty building at $240 a month?
Yes, but I don't believe that it's substantial competent evidence because the issue for the court wasn't storing that skylight in a football stadium or all by itself. It's what does it cost to store it? And the answers to those questions were not allowed. So the evidence given to the court was in a vacuum.
Did you proffer to the court any testimony that you wished the court to consider that was not considered?
I wasn't trial counsel. The record
understand.
reflects no proffer that I'm aware of.
Well, then you understand that that's the end of that story.
If that's what you're telling me right now, yes, sir. I'd just briefly like to address something that counsel said in regard to Judge Evander's questions. Has a judgment been paid? Yes, bonds are posted in full amount of attorney's fees, supersedious bonds, cash bonds, and what's coming back to this court, and I would suggest probably to this panel, since you already know the case, is
We hope not.
all the questions that you're asking now about the storage. I'd also say...
Let me ask you this. The trial judge's provision on $8 a day forever and ever gives me some real problems. But I also understand Mr. Whitehead's argument that it's not raised in your brief. What's your response to that?
Well, actually, it's not briefed in the brief. It is raised in a portion where, in saying what we're complaining the judge did was entering an order that allows the charges to accrue, as Judge Evander said, ad infinitum without a way to cancel it. There's no way to cancel it. We can't even do it by a bond posted according to the appellate rules.
Is that case briefed already?
Yes. Appellee's answer brief is due today, so I assume, unless you ask for an extension, it would be briefed today. We don't anticipate filing a reply brief to it, at least it's a pure legal issue, the questions, of course, answer. And the last thing I would say for the court, so I don't go too far over time, the argument about agency and these people came to get a third party came to get the skylight, I'd like the court to note they didn't give it to them. The third party came and left with no skylight, asked for a skylight and got no skylight. There's no agency here, Your Honor.
Thank you.
I thank the court for its time, and we ask that you would remand back with a judgment for the defendant. Thank you.
All right, thank you.
Thank you.